All right, COM 330, Chapter 16, Access to Courts, an important part of communication law. We look at the question, why should the press have access to courts? Now, if we were in a class where people were responding, this would be a great place to ask that question, and we might have some different responses, and that would be an interesting debate. Since we're not doing that, we'll go straight to the things that the basics for where we start. Basically, that is the First Amendment. It is part of having an informed public. Now, other countries that are democratic in general don't necessarily have this as far as the right to go to trials and film trials. In the United States, it varies from state to state. Some states allow it and some states do not. It's not a federal law. But the Bill of Rights has some information that is very important to how we look at things. An example of what I was going to say, though, is Canada, in that Canada is not a country that has a lot of information that comes out of the courts. We take for granted that you can find out about courts from day to day. In Canada, once everything gets into the system, a lot of information is banned from reporting on, even if you have the information, and that wouldn't happen in the United States. In fact, there are some trials that we still don't know exactly what happened because there is so much protection over the courts and less of a right, First Amendment right, a Bill of Rights, the right for free expression. So the debate. Two rights which must be balanced. Now, we talked about the First Amendment. The people have a right to know, but this must be balanced against something else. The first is the First Amendment, free press. Now, there are 5 parts of the First Amendment. Free press is the one people usually think of, but there's another right that must also be balanced. Number 2 is the Sixth Amendment, and that is a right to a fair trial. Most people, if you said, what is the Sixth Amendment? A lot of people would not know. But we would know that we do have a right to a fair trial. Now, what happens if that right for the public to know comes in conflict with the Sixth Amendment? What will happen? Well, the courts have looked at that, and we're going to take a look at some of the things that have happened. There are 3 ways, first, that the press can hurt a trial. We're talking about First Amendment against the Sixth Amendment. So 3 ways that the press can hurt a trial. And here you see a copy of the New York Times. There's Harvey Weinstein, and the headline is Harvey Weinstein paid off sexual harassment accusers for decades. And there he is waving at people. And you might not remember him before he was imprisoned. For many years, he was the top producer of movies coming out of Hollywood and had very many friends with the top movers and shakers in Hollywood. So that's a very recent trial. So one of the things is that you can taint the jury pool. Now, what does it mean to taint the jury pool? Well, if you taint some well water or a drink, that would be like putting something poisonous in it that will ruin in the case of a jury, it would ruin the trial. So you don't want to have something that disturbs the jury. So, Weinstein lawyers claimed that the trial should be moved. His main lawyer is the young lady in the back with the black coat, and she asked that the trial be moved to another location because of all the pretrial publicity. Everybody knew about Weinstein and all of these stories, salacious stories, which seem to have a lot of facts around them, seem to be very well supported. So there was a claim that they needed to move the trial because they couldn't get a good jury in Manhattan, New York. Now here's a headline that says, Manson shows headline to jury, mistrial bid fails. Now, this has to do with Charles Manson. You've probably heard about Charles Manson, the celebrated mass murderer. and I say celebrated, notorious, but a lot of movies have been made about him because it was just such a sensational things that he did in a sensational trial, sensational times. So this is an example of tainting the jury. Here you have Charles Manson, who tried to taint the jury by holding up a copy of the Los Angeles Times. And as you can see here in the picture, it said Manson guilty, Nixon declares. Well, who is the Nixon that declares it? It was Richard Nixon, who was the president at the time. So imagine if you were in a trial and a headline someplace said, President Trump says Bob Smith is guilty. And then Bob Smith gets the paper and he shows it to the jury. And he did that on purpose to get the whole trial, have a mistrial, to get everything thrown out. He was trying to disrupt the proceedings. And that's an example of somebody trying to taint a jury. This was the actual headline here. So he did hold up that newspaper, and that was one of many ways that they tried to disrupt that particular jury. The judge did not allow a mistrial in that case. Number 3, disrupting the court. And this is because there's a concern of a media circus, and they always use that in terms of the media coming in a court trial, and so much is going on with the cameras and other things that it distracts the justice process, and that definitely can happen. It's happened a number of times, and we'll take a look at that. So here is a couple of pictures from the Charles Lindbergh house, and this was on the East Coast. Now you might be familiar with Charles Lindbergh in St. Louis. His airplane was the Spirit of the St. Louis, and I think they had a replica of it in the airport in St. Louis at one time. But he lived in St. Louis for a while, a very famous pilot, first person to make a transatlantic flight alone, and very, very celebrated. So when he was already a celebrity, somebody climbed into his house, not in St. Louis, but on the East Coast. Somebody climbed into his house and took his child, stole it, kidnapped it, and this was a huge, sensational story. I remember my mother hearing about the story of Lindbergh's child being stolen. So you see down here it says Charles Lindbergh, child stolen. It has a picture of the child. And so this was a huge case, and it was unprecedented at the time. They'd had a lot of cases, but this was the worst. So this started, the whole idea of the media circus started with the Lindbergh baby kidnapping. It was in 1937. It was a while ago. And you had a lot of electronic media that was new, and so they didn't know exactly what to do with the media, and it began to disrupt the trial. So now Lindbergh, as we said, was a famous pilot. Here's the Spirit of St. Louis that he flew, and handsome guy. They looked like a wonderful couple. This was before the Kennedy couple. John F. Kennedy and his wife were considered Camelot, the perfect couple, but it was a handsome couple with his young wife, and they had a baby, and so this was very sensational when this was broken up. Incidentally, there is a Peoria connection to Charles Lindbergh. He used to fly mail in the early days of flight, and one of his stops was at an airport here in Peoria. Now that airport has been built over, there are some other buildings on it. He actually used to fly into Peoria, and then he would fly up to Chicago. He also knew a lot of people in Chicago, like the McCormicks and some other people who were the movers and shakers of Chicago. So at a later time, the baby, while there was the search was going on, the baby was found dead. It had been killed. And it seemed like America mourned it along with them. Now here are a few pictures of the man that was arrested. His name was Hauptmann, and you see the headline here in the Sun. He sobs and denies his guilt. He was an immigrant, and he spoke with an accent, and some people have kind of demonized him in general. Now, had he actually done it, he almost certainly had something to do with it. Whether he actually had done everything himself, but he definitely, from the evidence they found a lot of the money that had been given was found in his shed, and I don't think I've heard anyone suggest that he was set up with that, so he definitely had something to do with it. So reporters began to interrupt the trial. They mobbed it, whether they were on the outside, the inside. Nothing could get done. There was constant distractions. And even though Hauptmann had almost certainly done it, a lot of people said he didn't get a fair trial. And you need a fair trial, whether you're innocent or not. So the American Bar Association recommended banning cameras in the courtroom. American Bar Association is very powerful because it helps regulate the system of law. For them to say cameras should be banned in the courtroom was a big step. Now today the media uses, generally when they do have cameras in a courtroom, uses a single remote controlled camera rather than having an actual person there. This is when they are allowed, and it works on a case-by-case basis. However, in general, Illinois is a pretty good place for cameras in the courtroom. Missouri, and I used to be a reporter in Missouri and think I wished I lived in Illinois because we weren't allowed anywhere near a camera in a courtroom when I was reporting in Missouri. Now here's a picture of Jodi Arias, and this is more recent, a few years ago. But this Jodi Arias trial was considered a media circus. There were attractive people. There was a sensational murder. There was a lawyer who was dramatic. And this kind of reawakened the debate about whether Jodi Arias was getting a fair trial. Now, was she getting a fair trial? I would say it was highly likely that she had done it. There were a lot of pictures that had been taken at the time that showed that she had. But was it a fair trial? I would say the media did interfere. Now here we have O.J. Simpson and his lawyer. And it seemed like everybody in the O.J. Simpson trial was grandstanding. There have been a couple of movies out since on Netflix, but O.J. Simpson had some of the best lawyers in the United States. They called it the Dream Team, and all of them wanted to be on television and show how good they were. And this is Johnny Cochran, who was great. There was F. Lee Bailey and Kardashian, who was the father of some of the Kardashians. And so I guess he was Kim's father, I believe. And the judge in the case also was dramatic, and the prosecution was dramatic. And so a concern is that cameras motivate lawyers, witnesses, and judges to grandstand. So they see that camera and they want to look good on camera, and that's not always good for justice. Well, here are two other lawyers of the O.J. Simpson case, Marcia Clark and her assistant, and they also were very dramatic. However, both lawyers on both sides of the O.J. case and the judge were accused of grandstanding. It was a nationally broadcast live trial, and it was not what you would hope for if you were looking for a great trial. So, let's look at some other problems. Pre-trial publicity problems. That's problems before the trial. One of the first is, or the first that we're going to look at, is prior criminal records. And prior criminal records have to do with perhaps a an alleged perpetrator has a prior criminal record, the court doesn't want that necessarily to come in. For that to come into the trial, you have to show that there was a connection. Because just because somebody killed one or did one crime doesn't mean they've committed another. However, because of the First Amendment, the media, including social media, is free to discuss it. Courts, however, as I just mentioned, don't usually allow prior criminal records as evidence. They don't want to say, well, these are the usual suspects. This person has been in trouble before, so we're going to show that they have had a criminal record. Maybe they were trying to turn the corner, turn over a new leaf, and so the justice system usually doesn't allow that. I think that's a good thing. Courts look at only the current charge in general, unless you can find a reason to suggest that there's a pattern that the perpetrator is conducting. Another problem is confessions or admissions. You might have somebody say there was a confession or admission, and that can taint the jury. Now, the media is allowed to discuss it. If there's a confession or admission, the media can talk about it. There's no ban on talking about it. However, a confession without the subject being Mirandized, which is you read their rights, may not be allowed in court. Actually, sometimes they are. There are certain circumstances where it has been allowed, but mostly, as a general rule, you have to have your rights read, and very carefully, or the confession will be thrown out. And it's not uncommon for confessions to be not allowed in court. Now, number 3, problem with pretrial publicity, the results of tests. Now, you can see a gentleman here is hooked up to a lie detector test. The problem with lie detector tests is that they are not very reliable, and sometimes they detect lies when there actually was just nervousness or a person being upset because maybe they're upset because they're taking a lie detector test. So the results of tests are not allowed in court. Generally, some may not be allowed in court, but of course the media is allowed to discuss them. Number 4, opinions about the subject. Here is the example of the Nixon declares Manson guilty, and people might give their opinions, and that could sway some jurors. And so there's a concern about that as well. Now, number 5 is speculation about evidence or witnesses. And this might be, there might be a newspaper article that says perhaps one of the witnesses has a criminal record for embezzlement or lying and or fraud, and so maybe that's not going to be allowed in the court for some reason. It might in some cases, but the court doesn't want to have that a jury that's been tainted with things that they are trying to keep out. So those are some things in regard to pretrial publicity. Now, when I was a reporter, we would often get calls from a lawyer who would say, this is so-and-so lawyer, I want to get everything that you have on this court case. And it would be the lawyer representing that criminal defendant, and we could... At first, we would give it, and then later, I think we went to a system where you had to get a subpoena to get anything. But I remember at first, we would just, whoever answered the phone would have to be in charge of getting all that information. And they would use that to show, look at all of this media in the area. How could people not know about or be prejudiced about a client or a alleged perpetrator?